In Chapter 9, we discussed the fundamental transactions where shareholders have a right to vote. Remember, shareholders don't have a right to vote on every business transaction or every decision that the corporation makes. They only have a right to vote on a very few number of fundamental transactions. I use the mnemonic device MADS to help me remember the fundamental transactions. You can come up with your own mnemonic device if MADS is not helpful for you. But the four basic categories of fundamental transactions are mergers, amendment of the Articles of Incorporation, dissolution, and sale of substantially all of its assets, when a corporation sells substantially all of its assets. In each of these categories, the shareholders will have a right to vote on the transaction. In Chapter 5, we already discussed amendment of the Articles of Incorporation and when shareholders and how shareholders will vote on amendment to the Articles of Incorporation, so we're not going to revisit that here. Dissolution is pretty easy. If the board of directors decides to dissolve the corporation, the shareholders have a right to vote on that decision. They have a right to approve that decision or to reject that decision. So we're not going to discuss that any further. What we're going to focus on in this online lecture are what we call mergers and acquisitions. And as far as the fundamental transactions go, that includes mergers and sale of substantially all of a corporation's assets. The idea of mergers and acquisitions is that one corporation wants to acquire the business of another corporation. You can do that through a merger, or you can do that through the target corporation selling all of its assets to the acquiring corporation. There are various ways to structure these transactions. We'll talk about the different structures of mergers and acquisitions, and we'll talk about when the shareholders will get to vote on the various different structures. Let's start by looking at the basic acquisition structure. Here's our setup. We have A, the acquiring corporation, and A's A&L. That just means within A has its own assets and liabilities. And then we have T. T is the target corporation, the target business. A wants to acquire T's business. And we can see that T has T's A&L. That's just T's assets and liabilities. That's all of T's business. T is owned by T's shareholders, and A is owned by A's shareholders. So we have the acquiring corporation, A, the target corporation, T. We have T's shareholders and A's shareholders. Now, in the basic merger transaction, T is going to merge into A. Right? This is what we call the statutory merger. The result will look like this. We have A as the surviving corporation. We're going to use that term. A is the surviving corporation. A is left with A's assets and liabilities. Naturally, it had its own assets and liabilities. It survives the merger, and it has its own assets and liabilities after the merger. T no longer exists as a separate entity. A has effectively swallowed up T. So now T's assets and liabilities, all of T's business, is part of A. What's the voting in this transaction? We're going to go through this transaction, the statutory merger. Who gets to vote in this transaction? Well, both boards will vote in this transaction. So A's board will vote in this transaction to approve this merger. T's board will vote to approve this merger. T's shareholders will definitely get to vote in this transaction. A's shareholders may or may not vote in this transaction. It really depends on how we structure it. All right, now moving on. What happens to the shareholders of each company in a statutory merger, right? What happens to T's shareholders? What happens to A's shareholders in a statutory merger? Well, the answer is somewhat simple. Whatever the merger agreement provides, whatever the merger agreement says happens to these shareholders, that's what happens to these shareholders, right? That's not very helpful. So what typically happens? Let's look at what typically happens to the shareholders of the acquiring corporation and the shareholders of the target corporation when we do a statutory merger. This is our basic transaction. We have A and T. We also have A's shareholders and T's shareholders. A wants to acquire T. T is going to merge into A. Our question is, what happens to A's shareholders and what happens to T's shareholders in this merger? Well, here's our result. This is what could happen. The surviving corporation is A, and A's shareholders are still the shareholders of A after the merger. What happens to T's shareholders? Well, T's shareholders in the transaction receive cash and or debt securities in the transaction as consideration. So in this transaction, T's shareholders are cashed out of their position in T as a result of the merger. This is what we call a cash out merger. T's shareholders, the target shareholders, receive cash and or debt securities in the transaction. They are cashed out. There's another possible result. We could have a result where T's shareholders, T's original shareholders, receive A stock in the transaction, and they are now the new shareholders of A. So in this transaction, in this version of the statutory merger, T's shareholders survive the merger and they receive A stock in the transaction, and they are now the new A shareholders. Well, what happens to A's original shareholders? Well, they are cashed out in the merger. We could have a third possible result. A's shareholders maintain their shareholdings in A after the merger. T's shareholders get A stock in the transaction, so they are now part of the new shareholders of A. Let's talk about shareholder voting rights in merger transactions, in the statutory merger. Remember, in a statutory merger, we're going to have a surviving corporation. One corporation will survive after the merger. And we have a non-surviving corporation. One corporation is going to be merged out of existence. The shareholders of that corporation, the shareholders of the non-surviving corporation, will always have a right to vote on the merger transaction, no matter what. The shareholders of the surviving corporation will only have a right to vote on the transaction in a few limited situations. Let's talk about those situations. The first situation is where the surviving corporation must amend its articles of incorporation to accomplish the merger. If the surviving corporation's articles of incorporation need to be changed to accomplish the merger, then the surviving corporation's shareholders will get to vote on the merger. What's the most common example? Well, the most common example is increasing the authorized shares. The surviving corporation might need to increase its authorized shares to accomplish the merger. Here's an illustration. In our hypothetical merger, before the merger, the surviving corporation has 15,000 authorized shares of common stock in its articles of incorporation. 10,000 of those shares are already issued and outstanding. So in our hypothetical merger, the surviving corporation will issue 9,000 shares of surviving corporation common stock to target shareholders as consideration for the merger. You'll notice that the surviving corporation only has 5,000 authorized shares remaining to issue. It has 15,000 common stock, 15,000 shares of common stock authorized in its articles of incorporation, but 10,000 are already issued and outstanding. Therefore, to be able to issue 9,000 shares of common stock to target shareholders, the surviving corporation will have to amend its articles of incorporation to increase its authorized shares. The next situation where the surviving shareholders will get to vote on the transaction is where the shares of the surviving corporation shareholders will change somehow. Let's look at an illustration. Imagine our surviving corporation before the merger. The shareholders hold 10,000 shares of common stock. After the merger, the shareholders are going to hold a different number of shares. So for example, maybe the surviving shareholders, instead of holding 10,000 shares of common stock, they're going to be holding 20,000 shares of common stock. Or maybe they'll hold 5,000 shares of common stock. If you're going to make that change in the merger, the surviving shareholders will have a right to vote on the merger. Maybe you're going to change the designation of the stock. So for example, maybe after the merger, instead of holding common stock, the shareholders are going to hold common A. You have now changed the designation, and the shareholders of the common stock will get to vote on the merger. Let's consider a situation where our pre-merger surviving corporation also has preferred stockholders. Maybe it has a Series A and a Series B of preferred shares. And somehow the preferred stock is going to change in the merger transaction. After the merger, the preferred stock is going to be different than it was beforehand. In those situations, the preferred stockholders will get to vote. What type of changes might there be to the preferred stock? Well, there might have different preferences. Originally, you had a $5 dividend preference. Now you're going to have a $10 dividend preference or a $3 dividend preference. Maybe there's going to be different limitations on your stock, and maybe we're going to have different relative rights between the Series A and the Series B preferred after the merger than before the merger. In those circumstances, our preferred stockholders will have a right to vote on the transaction, even though they're going to be part of the surviving corporation. Finally, if the surviving corporation's voting rights are going to be diluted by more than 20% in the merger, then the surviving corporation shareholders will have a right to vote on the transaction. Let us look at an example, an illustration. So pre-merger, imagine pre-merger, our surviving corporation has 10,000 shares of common stock issued and outstanding. For this, we want to look at how much stock is issued and outstanding. We're not looking at authorized stock. So before the merger, the surviving corporation has 10,000 shares of common stock issued and outstanding. During the merger, it's going to issue 2,001 common shares to target shareholders. So in the post-merger, the surviving corporation will have 12,001 common shares issued and outstanding. You'll see that the original shareholdings of the surviving corporation, 10,000, their voting rights have been diluted by more than 20%, and just more than 20%. That's why I put 2001 instead of 2,000. Most jurisdictions, the rule is that the surviving corporation's shareholders will get to vote on the transaction if in the transaction their voting rights will be diluted by more than 20%. More than 20%. So the surviving corporation shareholders pre-merger had 10,000 shares of common stock. The target shareholders are going to get 2,001 shares of surviving corporation's common stock. And then in the end, after the merger, the surviving corporation will have 12,001 shares of common stock issued and outstanding. The change from 10,000 pre-merger to 12,001 post-merger is a dilution of more than 20%. And because of that, the surviving corporation's shareholders will have a right to vote on the transaction. Let's talk about appraisal rights in merger transactions. Appraisal rights are often called dissenters' rights. You will have appraisal rights or dissenters' rights if you are a shareholder in either corporation, you have a right to vote in the merger transaction, and you vote against the merger or you abstain. If you meet those conditions, then you have appraisal rights, and your corporation must buy your shares from you at fair market value. The idea is that if I'm a shareholder and I don't like the transaction, I don't like the consideration I'm receiving in this transaction, I don't think this merger transaction is good for me, I can say, I'm not going through with this. You have to buy out my shares at fair market value. And so before the corporation goes through a merger, it has to settle this appraisal rights issue. If it has dissenting shareholders, it has to buy out those shares before it goes through with the merger transaction. You can see this might be an obstacle for the merger. We've already talked about the statutory merger. Let's talk about another version of the statutory merger in our next transaction, which is often referred to as a short-form merger. In this transaction, we're going to have an acquiring corporation, and we're also going to have a target corporation. But in this case, A is the parent of T. The acquiring corporation is the parent corporation of T, and T is the subsidiary of A. What does that mean? Well, normally we'll say that one corporation is the parent corporation of another corporation when it owns a majority of the voting stock. So in this case, A owns the majority of the voting stock of T, and therefore A is T's parent and T is A's subsidiary corporation. If we want to merge T into A, we can, of course, use a regular statutory merger. And in a regular statutory merger, T's shareholders, you see those T shareholders over there? They would get to vote in the transaction. But in a situation where the parent corporation owns at least 90% of the voting stock of the subsidiary of T, then we do not have to go through the regular statutory merger. We can use something that is often called a short-form merger. What will the result be of this transaction? Well, the result will be that A will be the surviving corporation and T will be merged out of existence. That is what we call the short-form merger. Now, once again, the important aspect of the short-form merger is that we have a parent and a subsidiary that are merging, and the parent owns at least 90% of the outstanding stock of the subsidiary. Who will get to vote in this transaction? Well, the boards will vote. A's board will vote on this transaction, and T's board will vote on this transaction. There will be no shareholder vote in this transaction. And you might say, what about T shareholders, those 10% minority shareholders? Will they get to vote in the transaction? And the answer is no. Let's talk about our next transaction. We'll call it the share purchase. Now, the share purchase is not a statutory transaction. It is just a purchase of shares between two parties. How does this fit into our whole mergers and acquisitions scenario? Well, Once again, we have A, which is the acquiring corporation, and we have T, which is the target corporation. And we also have A's shareholders and T's shareholders. In this transaction, A is not dealing with T, right? Up till this point, we've had a transaction between A, the acquiring corporation, and T, the target corporation. In the share purchase, A is dealing directly with T's shareholders. A is going to buy the shares from T's shareholders. T's shareholders will sell their shares to A Corp in exchange for cash, stock, or some sort of debt security. So A is dealing directly with T, and A is dealing directly with T's shareholders, and A is interested in acquiring control, or more than control, 100% of the outstanding stock of T. This is what we call a share purchase or a stock purchase. The result will look like this. A will now be the parent A will now be the parent corporation of T, and T will be the subsidiary of A. T will not be merging into A in a share purchase. A is simply acquiring the outstanding stock of T. Right? And usually it is the goal of the acquiring corporation to get 100%, all of the outstanding stock of T. Who will vote in this transaction? Well, A's board will vote on this transaction, right? A is making a decision to buy the stock. Who makes the decision in a corporation? The board of directors. So A's board will vote in this transaction. There is no shareholder vote. There is a problem with this transaction, however. A is dealing with T's shareholders directly. Now, if there's one shareholder, then this is easy. A is assured of getting 100% because there's only one shareholder, and as long as T's shareholder wants to sell to A, then A is going to get 100% of the outstanding stock of T. But what if there are 100 shareholders? What if there are 1,000 shareholders? What if there are 10,000 T shareholders? A has to negotiate with each one of them individually, and we might have a holdout. Imagine if you're one of T's shareholders and you know that A wants to get 100%. You're thinking, I could be the one that holds out, and because I hold out, I'm going to get a little bit more money from A. Well, naturally, all of T's shareholders have the same idea. So because of this holdout problem, A might not be able to get 100%. And even if A does get 100%, A might have to pay a premium because all of T's shareholders know that they can act as the holdout. Now, there's a statutory way to accomplish the share purchase without having to worry about holdouts. In many jurisdictions, there is a statutory provision called a share exchange, or it's often called a mandatory share exchange, or you can even think of it as a forced share exchange. It is very much like a statutory merger. Let's look at the mandatory share exchange. Now, if you see, it starts out looking very much like the merger. We have A, we have T, and we have A's shareholders and T's shareholders. But in this situation, we are not merging T into A, right? What result do we want? Well, we want the same result that we would get if we had a share purchase, a stock purchase. If A was just going to acquire all of the stock of T, we would have A as the parent corporation of T, with A holding 100% of the outstanding stock of T. This is what we would accomplish with a regular share purchase, but with a regular share purchase, we have the problem of holdouts. In this version of the mandatory share exchange, which is a statutory provision in many jurisdictions, we can accomplish this without having to worry about the holdouts. How do we do this? Well, we just get voting, right? Both boards will vote, and T's shareholders will vote in the transaction. If a majority of T's shareholders approve this transaction, then this transaction goes through. And so the minority that vote against the transaction, they have no choice but to give up their shares in this transaction. And you can see it works very much the same as a merger, except the result is different. In a merger, T would be merged into A and T would be merged out of existence. In this situation, our result is that A is the 100% shareholder of T. A is the parent of T. T is A's wholly owned subsidiary. All right, and so the idea is that A will get 100% as long as a majority of T's shareholders approve this transaction. This mandatory share exchange, once again, helps A avoid the problem of the holdouts that A would encounter if A was going to do a regular share purchase. Now, if the jurisdiction does not have a mandatory share exchange statute, you can still accomplish the same transaction with a statutory merger. Let's look at how that would look. This is how you accomplish the same result as a mandatory share exchange using a regular statutory merger format. Remember, the goal is to create a transaction where A winds up holding 100% of the stock of T, and T becomes the wholly owned subsidiary of A. So how can we do that using a statutory merger? All right, well, this is what will happen. A will create a new subsidiary just for the purposes of this merger, and we'll call this A2. Sometimes it's called merger sub. So A creates this wholly owned subsidiary. The subsidiary will then merge into T with T as the surviving corporation. The T shareholders will be cashed out in the transaction. And you might say to yourself, wait a minute. If T is the surviving corporation, how can T shareholders be cashed out? Well, the answer is because that's what the merger agreement calls for. T shareholders will indeed have a right to vote on this transaction, but they will not survive the transaction. T will survive the transaction, but T's shareholders will be cashed out. If a majority of T shareholders approve this transaction, then this transaction will go through and we will have a merger between the merger sub A2 and with T as the surviving corporation. Let's look at the result. The result would look like this. A still survives, but now T is the wholly owned subsidiary of A. T's shareholders have been cashed out in the merger. Excuse me, not the merger. Well, it is a merger. In the merger between T and A's wholly owned subsidiary. Right? And so we've accomplished what we wanted to accomplish. We've accomplished the same thing that we would get in a share purchase. A holding 100% of T. We've accomplished the same thing that we would have accomplished through a statutory mandatory share exchange. A holds 100% of T's outstanding stock. All right, let's talk about the next transaction, which is a statutory transaction, sale of substantially all the assets. So we once again have A and T. A wants to acquire the business of T. So instead of merging T into A, T is going to sell all of its assets to A, and A is going to pay for those assets. This is substantially all the assets, a sale of substantially all the assets. You can acquire a business by purchasing all of its assets. In this case, by assets, we mean everything. We mean its fixed assets. We mean its contracts, its trademarks, its goodwill, everything. So it's effectively very similar to the merger in the sense that A is going to wind up with T's business, but it's different in one major respect, right? Here's the result. A survives, of course, this sale, and A has its assets and liabilities, but A has only acquired T's assets, not its liabilities. So after T sells all of its assets to A, T is still in existence. T survives, but it survives with its liabilities only and any consideration it received in the transaction. Remember, A is paying T for T's assets. So after T sells all of its assets to A, T is left with its liabilities and any consideration it received in the transaction. What's the voting in this transaction? Well, both boards will vote. A's board will vote on this transaction. They will vote whether they want to buy T's assets, and T's board will vote on this transaction, whether they want to sell all of its assets to A. T's shareholders will get to vote in this transaction. A's shareholders will not get to vote in this transaction. We know that immediately following the sale of substantially all of the assets, our situation looks like this. We have A and T both survive the transaction. A has its own business, it has its own assets and liabilities, and it also has T's assets. T, on the other hand, only has its liabilities and any consideration it received in the transaction. Now what happens? Well, typically, T will dissolve. It will end its existence and go through the liquidation process. What does that mean? Well, it will pay off any of its creditors. Remember, T still has its liabilities. It has to pay those off, and it will pay those off in the dissolution and liquidation process. Anything that is left over will go to T's shareholders. Remember, T's shareholders are the residual claimants. They get whatever is left over after paying T's creditors. Now, here's the interesting result. If the consideration that T received is A stock, as we said often, A will not pay cash for T's assets, but will use its stock. It will pay in its stock. So that consideration that T has is actually A stock. When that is distributed to T's shareholders, now T's shareholders become shareholders in A. It would look like this. When A uses its stock as consideration for the purchase of all of T's assets, and then T's original shareholders receive the stock in the dissolution process, the result is going to look like this. We have A that survives the transaction with its own assets and liabilities, the assets and liabilities that it had before the transaction, and it now has T's assets. A has its original shareholders, which we designate as A's shareholders here. It also has new shareholders, which we designate as T's shareholders. Those are T's former shareholders, and they are now new shareholders of A. And you can see how this looks very much like a merger transaction, the result of a regular statutory merger. But you can see there's one difference. In our statutory merger within A, we had T's assets and liabilities. And you can see now we only have T's assets. What does this mean? Well, some of T's creditors might cry foul. They might be unhappy with this transaction. And you might say, why? Well, remember, during the dissolution process, T's creditors were paid off. So when T dissolved and liquidated its assets, it had to pay off its creditors, but it really only had to pay off its known creditors. After the fact, there might be creditors that had contingent claims at the time of T's dissolution and liquidation, and they did not get paid off during the liquidation process. So say, for example, that T sold some sort of product a few years ago, and it turns out that this product causes cancer. Well, we didn't know this at the time of T's liquidation, but now we do. And the creditors of T, the people who got cancer from using T's product, they have a products liability claim against T. They want to sue T, but T no longer exists. T has no assets to attack. So who are you going to attack? You're going to attack A, right? And this is the successor liability doctrine. They will claim the successor liability doctrine. Not all jurisdictions subscribe to the doctrine of successor liability, but enough do so that we should understand what it is. And effectively, the creditors are saying that A should be liable for T's obligations. Now, in some jurisdictions that subscribe to the successor liability doctrine, the more that the result of the sale of substantially all of the assets looks like a merger, the more likely that a court is going to say, yes, A should be liable for T's obligations. Now, T's shareholders, at least the shareholders that were not in favor of the sale of substantially all of the assets, will cry foul also. Why? Well, because in many jurisdictions, in a sale of substantially all of the assets, the target's shareholders will not get appraisal rights. But if we had structured the transaction as a merger, they would have received appraisal rights. And so effectively, what they're saying is that this transaction looks so much like a merger. The result of this transaction looks so much like the result of a statutory merger that the court should treat it like a statutory merger. The court should call it a de facto merger. And because it is a de facto merger, I should have the rights that I would have in a statutory merger. Namely, I want appraisal rights. Once again, not all jurisdictions subscribe to the doctrine of de facto merger. Our last transaction is what we call a hostile takeover. A hostile takeover can occur in a situation where A wants to acquire T, but T's board will not cooperate. T says, thank you, but no thank you. We are not interested in a merger with you. So how can A force the merger if T's board will not cooperate? Well, A will try and gain control of T's board. How can you gain control of T's board? How will A gain control of T's board? Well, A will have to get enough voting power in T so that it can vote out T's current board and vote in a new board that will be amenable to a transaction with A. A is going to usually engage in 2 steps to gain control of T's board. First, A will make a tender offer to T's shareholders. A would like to acquire enough of T's voting stock so that A can affect a change in T's board of directors. So A will make an offer directly to T shareholders saying, if you tender your shares to me, I will buy them. Now, A will probably only make a tender offer for a certain percentage of T stock, whatever percentage A will need to gain voting control. It might be a majority, it might be a little bit more, it might be a little bit less. A will also take a second step to help A get control of T's board. A will engage in a proxy fight to replace T's directors. So A will ask for the proxy of T's shareholders. And A will say to T's shareholders, if you give me your proxy, I will vote it to replace T's current board with a board that is amenable to a transaction with me. And if T shareholders are in favor of the transaction, they will give their proxy to A. So that is a hostile takeover. That is where A engages in a tender offer and a proxy fight to gain control of T's board so that they can replace T's board with a new board of directors that will approve a transaction, a merger with A.